Hi, everyone. So glad you could join us today. I'm Katie Kiersey, and I run marketing and community here at Right Side Up. For the handful of you who aren't familiar with Right Side Up, we're a collective of growth marketing specialists who have helped more than 300 VC-backed tech companies hit their goals. We cover virtually all paid channels, SEO, CRO, email marketing, analytics, and more. Today's webinar digs into a very important topic, legal entity formation for independent marketing contractors. Many of the consultants we work with are first-time consultants who have spent most of their careers in-house as W-2 employees. They are without a doubt experts in their marketing craft, but working as a 1099 contractor requires an entirely different set of knowledge. One of the most frequently asked questions that arises among first-time consultants is, do I need to form some kind of a legal entity in order to take on clients? And if so, what's the right entity for me? It's a pleasure to introduce you to today's presenter, Alex King, attorney and founder of Archetype Legal, a Bay Area-based law firm dedicated to helping entrepreneurs, startups, and small businesses take practical legal steps to achieve their business goals. Archetype Legal is focused on corporate and partnership law with experience in issues of structure and organization, raising capital and financing due diligence, securities and equity compensation, ongoing corporate compliance, and joint ventures. We've invited Alex to lead the session on legal entity formation. He'll be discussing the advantages and limitations of sole proprietorships versus LLCs versus C-Corps, when to consider an S-Corp, tax implications for different kinds of business entities, and more. Before I turn it over to Alex, I wanted to mention a couple of important housekeeping items. First, please submit any and all questions you have throughout the session using Zoom's Q&A functionality at the bottom of your screen. We'll plan to address as many questions as we can in the last 20 to 30 minutes of this presentation. And second, we will be recording this webinar and sharing the recording with you along with Alex's slides via email in the next few days, most likely later this week. But for now, that's all I've got. So without further ado, I'll turn it over to Alex.
Thanks, Katie. Hi, everyone. It's a pleasure to be with you today. I'm looking forward to talking through some of these topics, as I think it is a very important topic for a lot of you attending, and really kind of all consultants in general, but especially marketing consultants. And this is a topic that is actually near and dear to my heart, as my wife is an independent brand strategist, left the hospitality industry years ago to kind of start her own small agency. And so, this is something that's not only a client-based issue that I've run through for years, but it's something that I've, dealt with within my own family. So looking forward to talking to you a little bit more about this topic. Second here, sorry. Oh, there we go. Here's a slide a little bit just about me, so we won't have to stay on it very long here. Katie did a wonderful intro about myself. I am the founder of Archetype Legal. We're a boutique agents law firm out of the Bay Area, with a small presence in Chicago as well. We're 5 attorneys focusing on all kinds of topics related to what I would describe as transactional business law, whether that's IP protection, forming an organization, selling your business, all the kind of variety of commercial transactions you might get into, from service agreements, consulting agreements, that type of thing. And so this is certainly, as I mentioned, a topic that we deal with all the time with our consultants. And so hoping to kind of give you a high level understanding of maybe what you want to consider as you're moving forward. Lawyers are the worst, so I'll give this upfront disclaimer that this is not legal advice. You really should consult with your own personal attorney when making a decision about how you're going to proceed on any of these topics. As we've found over, my nearly a decade of practicing, every situation is different and there's not a one size fits all. So you want to make sure, your specific situation is being addressed when you're considering how to proceed with things like entity formation or really anything kind of in the legal arena. All right, so, kicking this off, and what this is really about is, should you form a legal entity for your consulting business? And, there's a variety of things to consider here. Why would I maybe want to do this? There are 3 kind of primary benefits that we see consultants experience if they decide to go down this path. The biggest one that I can see is almost always liability protection. What happens by forming either an LLC, and we'll talk more about why most people that are in a consulting role will form an LLC, or whether it's a corporation. The idea here is that you are creating a separation of church and state, per se, and that now the client that is paying you for your services, if they have an issue, they are going to be suing or taking up that issue with your LLC or corporation. This is great for you, the consultant, because it means that at maximum, you are going to be liable, except in certain circumstances, up to the value of your business. Now, losing your small business can still be devastating. Do not get me wrong. It would not be great for my family for me to no longer have Archetype legal, but it means that there is a shield in which my other assets can be protected. Those assets can include things like your personal bank account, your home, your car, other type of, savings and assets that you might have. And so creating this shield can go a long way if you have kind of a big whoopsies that would result in large liability. There are certainly other ways you can go about adding these protections as well. Having your own contract that may set the sandbox and limitations of exposure of liability, having insurance, and just the quality of your work can all go a long ways. But we're all humans, we all can make errors. And so having kind of this LLC protection can really go a long ways, or a corporation protection. But again, we'll talk a little bit more why we see a lot of people do the LLC. The other thing, and I'm talking about this again at a high level, so this is far from a guarantee that it will work out this way, is that a lot of our clients experience a tax savings. They're able to do this almost exclusively by forming an entity and then electing to have that entity taxed as an S-Corp. I will say this numerous times throughout this talk, but one thing that's very confusing, and lawyers and CPAs and other professionals have done a bad job of explaining this, and that is why it is so confusing, is that an S-Corp is just a tax election. It is not a legal entity. A legal entity is something like a limited liability company, a corporation. If you are a professional consulting firm, like a law firm or a CPA, it can be a professional corporation. Those are the legal entities. From there, that legal entity can either accept its default tax status, or it can make an S-Corp election. An S-Corp election is a popular election to be made for small businesses and can be made by LLCs, including LLCs that are just single owner LLCs. Why would somebody maybe want to do this? The reason you would want to do this is that if you do not make any type of a tax election, and by way of example, you form a single member LLC, you are going to effectively have the exact same tax rate you would have as if you were just a sole proprietor. Now, that's not necessarily a horrible tax situation to be in, because it's all just one tax. There's no double tax like a C-Corp, but it means you're going to be paying all of the self-employment taxation throughout the entire process of the experience. As opposed to effectively, if you were an S-Corp, you could set yourself up on a reasonable salary and possibly take the rest as a profit distribution, and those profit distributions would avoid the self-employment tax. The other thing we see, and this is kind of a smaller one, is marketing. And this can go a long ways to kind of legitimizing the business. It is just gives more cachet and prestige to say, you're working with Archetype Legal than it does to say you're working with Alex King, the lawyer, right, as kind of a sole proprietor. And so it kind of adds a little bit of gravitas and size to the business. And this can go a long way to kind of landing clients like a Right Side Up Capital, Facebook, Google, whoever it might be. So what are some of the pros and cons of, say, a sole proprietorship? Well, a sole proprietorship, the nice thing about it is it's truly the simplest business structure, right? You're absolutely going to be able to not have to pay any like franchise taxes to the state of California. You're your own boss. There is no kind of, but that comes with a little bit of a double-edged sword, which I'll talk a little bit about. And as mentioned, the taxes are pretty simplified. You report your income on a Schedule C, and you basically have everything flow down to you. As mentioned, though, the cons of a sole proprietorship are the exposure to extended liability. If you're a sole proprietor, there's no opportunity to make the S-Corp election. And so if somebody like your CPA would indicate there are some tax savings to be had, you cannot have those. And it's hard to, if you're ever going to kind of expand or kind of get bigger, convince sophisticated investors or partners to join you. Right? You may very well see some strategy to having other people join you as kind of partners in what you're trying to do. And if they're really kind of paying attention and talking to a lawyer, they're unlikely to really want to join you and just be your general partner, because they too will be exposed to unlimited liability for what the business is doing. And so this creates quite a bit of downside to remaining kind of as a sole proprietor. you know, how you're going to do it. But to give an example, we certainly are not the type of office that says everybody has to be some type of legal entity. To use my wife again as an example, she left the hospitality industry. And for the first year, it was a lot of just kind of boots on the ground, trying to build up a book of business. And so for the first 6 months or so, we didn't form any type of entity. She started to land quite a few clients. It made sense from an exposure standpoint. And so we flipped the switch kind of the beginning of the following year. So, you know, it does come with added cost to have like a legal entity. And so it has to be weighed against kind of the facts and circumstances of your business. You're almost never going to want to be a C corporation if you are going to form a legal entity. It's almost always going to want to be an LLC. You'll typically hear C corporations are only really good if you're going to be kind of your traditional tech startup. If you are kind of a traditional tech startup, you're going to want to be a C corporation because of the fact that you are going to take on VC capital funding. That's almost never going to happen for a small consulting business, including even a business like my own, right? It's not limited to a marketing consultant. It's limited to most consultants, unless you've got kind of a business that can kind of scale really quickly because of a tech component or something like that. You're almost always going to want to be something that would allow you to be, you know, very lean and have kind of one layer of taxation. It's much more expensive to incorporate. There's much more you're going to have to follow here. You're going to have to set up like a board of directors, have annual shareholder meetings. And the worst part about all of it is going to kind of be the double taxation. Double taxation means that the entity itself is going to first be taxed before any of the profits that are left over can be distributed out to the owners. Once those are distributed out to the owners, then those owners pay taxes. That's almost never going to be good, right? Venture capital firms that are investing in these C corporations, they almost never are making any profit for years and years. They're often loss leaders until such time that they can kind of flip the switch and either IPO, maybe be acquired, et cetera. But the double taxation is a little bit of a paper tiger because there aren't really any profits to be taxed on. So it's not nearly as big of a deal here. You as a consulting business are hoping to make profits almost from day one. You can probably be pretty lean. You may not be needing much beyond a little bit of equipment. You may not be needing some big office space or anything like that. And so you are going to almost certainly have some profits from the jump. And the way in which you can protect those by paying the least amount of taxes is going to be very valuable for you for years to come, if not right from the beginning. As well as, let's flip it to the other side. If it's going to take you a little while to kind of get rolling, if you are a pass-through entity like a single member LLC or an entity that's taxed as an S-Corp, if you have losses at the beginning, you can take those losses personally against any other income you may have, whether that be income from other investments or things you have you know, coming your way, or you can kind of hold off on them and possibly write them off against future earnings after the business kind of starts to turn the corner in the way you'd like. A lot of people come to us and say, hey, listen, everybody's telling me they're incorporating in Delaware or Nevada. Is that what I should do? And the answer almost always is no. The reason being is that you're going to hear that people are incorporating in Delaware or Nevada because of the fact that, again, they are likely trying to be a startup kind of tech company that is raising capital from VC investors. And the reason that they're doing this is because they want to have a structure in place that is attractive to venture capitalists. Without getting too deep into it, a Delaware corporation is much easier to make amendments to once you're making time to like create preferred classes of stock for investors. The rules are much better understood. There's a court of chancery that resolves disputes quicker. These are all factors that VC investors like. You don't need any of this because you're not going to be taking on VC investors. Another myth is that, hey, I'll save some taxes if I'm in Delaware. Sure, that would be possibly true if you were only registered in Delaware, but unfortunately, that's not really how it works. And if we break it down, it makes sense, right? So basically, California's position is if you're located here and you're doing business here, you need to pay our taxes because, hey, we're the 6th or 7th largest economy in the world, not even just the United States. And so if you're going to take advantage of everything we have to offer you here in the state, you need to be paying our fees. So we don't care that you registered in another state. You need to register that entity here as well. and make sure that you're paying your taxes. So really what you'd be doing is actually increasing your fees, by having to pay now fees in Delaware, Nevada, Wisconsin, wherever it is you registered, and then also the fees kind of here. If this rule didn't apply, look, no one would ever register to do business in California. Everybody would pick someplace like Nebraska, where I think last I checked, it's like $50 a year to have an entity. And they'd say like, oh, that's where my business is located. But that doesn't really pass the test if under scrutiny, if we're really looking at it. If you're located here, if you're paying personal income taxes here, if all your operations are here, California is going to say, listen, you need to be kind of registered here as well as a foreign entity if you started in Nebraska, Delaware, Nevada. And so, you're really just kind of adding to your costs by going to another state. Again, going to another state really only makes sense if you are under two circumstances. One is if you actually have a presence there. I think I mentioned at the top of the hour, we have kind of a satellite office in Chicago. So Archetype Legal is registered as a foreign professional corporation doing business in Illinois because we do have an office there. And so we have to pay taxes and fees there. So I'm not saying it's out of the question, but that's really either you're doing business there and you have kind of an office there, or you would be the type of entity that's seeking VC investment, which, again, under the topic we're addressing or not. Otherwise, you're just kind of adding to your costs and paying more to be in a state that's not really adding any value to your operations. So why kind of would we think more about going kind of in the limited liability company over kind of a corporation? As mentioned kind of towards the top, whether you form as an LLC in California or whether you form as a corporation, either can elect to be taxed as an S-Corp, okay? If you form as a single member, meaning a single owner, the default taxation for an LLC is a pass-through, what's called disregarded entity. That means you're taxed the same as if you were a sole proprietorship. If you form with multiple partners, meaning multiple owners, you're taxed as a partnership, which is still just one taxation, but is slightly different from like a Schedule C sole proprietorship. But if you form a corporation, it's different. The default is actually the C Corp. And we talked about the C Corp. That's not going to be a structure you're going to be very excited about because of the fact that the C Corp taxation is the double tax, and you're not going to want that. So your only really option there to get it down is to do kind of the S Corp taxation. We're not going to want to kind of do that here because of the fact that, we're not, we would want to, in my opinion, have more flexible options. And the more flexible options are to do the LLC, because the default of the LLC is still a pretty popular tax structure with just one layer. Or if you talk to your CPA and you want to kind of make an S-Corp election, you can kind of consider doing that. There's some pros and cons to the S-Corp election. And there's a reason sometimes people would not want to do it. And that's why the LLC as a starting point can make a lot of sense. If you make the S-Corp election, you now must establish payroll because you are now a W-2 employee of your own entity. So you need to pay yourself a reasonable salary, usually thought of as about half of what you're making, and then take somewhere in the neighborhood of the other half as a profit distribution. So by way of example, if you would normally make, just to use round numbers, $80,000, you would set your salary up as $40,000, take the other $40,000 as a profit distribution. But setting up payroll of any kind comes with costs, right? It comes with things like having to establish somebody to run it, somebody like Gusto, which is who we use. I think they charge us somewhere in the neighborhood of $50 a month. You add that up over 12 months, that's $600. Now, I just need to do it. I have a staff with employees, but if I was a solo, you could start to be like, well, is that $600 really saving me enough in taxes as the S-Corp? There's other limitations with an S-Corp. An S-Corp has to be owned by US residents who are here kind of on a permanent basis. There's obviously an opportunity that maybe you would want to partner or yourself go overseas and not be based here in the US, and that's not going to be something you can do as an S-Corp. So maybe you want to fall back on kind of the default LLC, which again still has pretty favorable tax rates, and why you'd want to consider doing it. The other thing you may want to consider, or why an LLC makes a lot of sense, is it's more flexible of a management structure than a corporation. We talked about this a little bit here, but a corporation is going to require you to have a board of directors. It's also going to require you to hold like annual shareholder meetings. Now, that's not incredibly hard if management and ownership's pretty small. the board is just simply you and you're the only shareholder. It's not hard to write annually that you're electing yourself back on the board, that you are going to, saying that you are holding a board meeting to kind of decide these type of things. But in a perfect world, you wouldn't want to do these type of things because it's just another thing that you're expected to do to abide by kind of corporate law. And the failure to do it could expose you to a claim of what's called piercing the corporate veil. Argument here is, hey, judge or arbitrator, whoever it is you're in front of, look, like Alex never even held a single board meeting. He never held a single shareholder meeting. How seriously did he actually take running this business? It looks like it's really ultimately just a sole proprietorship. Let us sue him personally. That will allow for a more equitable result. That's a pretty extreme remedy. I'm not trying to say it happens with any frequency, but it definitely is something that you would want to kind of think about as just kind of an added kind of what you need to do when moving forward. The other thing I didn't mention is that if you do have a partner in your business, is that you can, if it's just an LLC instead of an S-Corp, you can have more flexible profit distributions. In other words, I can own 60% of the LLC, but agree to accept only 40% of the profits. You can't do that if you're an S-Corp. If I own 60% of an S-Corp and we're distributing the profits, I have to receive 60% of the profits. So it's kind of a more stringent kind of profit distribution structure. There's definitely going to be some limitations. If you're an LLC, as we talked about, a judge can rule under kind of a piercing the corporate veil theory that they should be able to kind of come after you. The way we typically see that, if that's ever going to be an argument, is that you don't really do much beyond kind of just registering the LLC, with the state, and then you never kind of establish your own bank account. You fail to kind of operate clearly through that. You commingle funds, buying yourself like a personal sweater out of the business account as opposed to just only having it for business expenses. But if you establish an LLC, you do things like get a business license and do kind of a standard thing that business owners would do, then you are going to be able to have the liability protection that you desire. You are going to be kind of personally still responsible for your taxes. And so that means that you have kind of all the taxes that flow down through to you, and you can even potentially have what's called like phantom income if you're in a partnership. In other words, if the LLC makes $50,000 and I own 50% of it, I am expected to pay taxes on that $25,000, even if that money is not distributed out to me. Now, if I pay those taxes and it's distributed out to me at a later time, I'm not going to be taxed a second time. But that becomes kind of a tax planning strategy that you're going to kind of have to think about. If you have kind of an LLC with multiple partners and one member leaves, that can create some kind of issues for kind of the continuation of the LLC. But most of the time, if you are, especially in the state of California, operating an LLC with multiple members, we strongly advise you consider an operating agreement, which is kind of the partnership agreement between multiple members. And that allows you to establish rules and procedures for what would happen if a member were to leave, to allow kind of continuation of the LLC. We talked about this already, so I won't belabor it too much more, but oftentimes you want to consider an S-Corp election because of your opportunity to save money on taxes. Now, if you're an entity like myself, which is a professional corporation because lawyers cannot form LLCs, I really kind of had no choice but to make an S-Corp election. Otherwise, the default would have been the C-Corp structure, which would not have been good for me by any means. And since I can't form an LLC, the only way I could get one layer of tax is to make an S-Corp election. Again, if you're forming like an LLC, if you're forming a corporation, I think you're almost never going to want to be, again, the C-Corp structure. So it's kind of a no-brainer. But if you're forming an LLC, it's not always a no-brainer by any means. As mentioned, now you need to establish payroll. If there are multiple members, profits have to be distributed based on ownership. There's rules and regulations about who can own an S-Corp. Again, you can only have 100 shareholders. That's probably not going to be a big issue for small marketing consulting businesses. But those owners do have to be natural people, meaning they cannot be another LLC. And everybody has to be kind of a US resident. And so, a lot of times there is just more flexibility in just a more standardized single member LLC with no S-Corp, or multiple members, but again, no S-Corp. But it's worth thinking about because you can save on some of those self-employment taxes. Those self-employment taxes can, add up to, in the 7 to 11%. that you'll want to kind of talk through with your CPA. So depending on how well the business is doing, if you would have otherwise normally gotten that 100 grand with all the self-employment taxes, that could be somewhere in the $5,000 to $10,000 of tax savings, which is, a good amount of money, and obviously highly justifies the extra expenses you have by establishing like payroll and things like that. So again, if you're just a sole proprietor, you have really no options here. You have to just be taxed on your Schedule C on Form 1040. You are not allowed to make an S-Corp election. You're still allowed to treat it like a business, meaning if you have business expenses, those can be written off against your income. If you're buying yourself a new Mac computer or a cell phone or office space or whatever it might be, all of that can be deducted against what you're having. So you're going to be taxed very similar, if not identical, to what a single member LLC would be taxed as if that LLC did not make an S-Corp election. But, again, the downside to the sole proprietorship stems heavily from the idea that there is no liability protection unless you can create some of that protection using another source, whether that be something like business insurance, a good contract, or just kind of the quality of your work. But with the LLC, provided you are operating it as you should be, which again is not very hard, there's not a lot of formalities to do. The goal here is that if there was to be an issue, now the customer that you have engaged with, and extends beyond customers, right? We often sometimes think about just like our clients get mad at us, but we could also think about if we had an employee get mad at us, if we had a vendor get mad at us, if we had another sub-consultant that we were using on a project get mad at us, they're now contracting with our entity and not us as an individual. And so now if they are going to sue us, if they are going to get mad at us, etc., they are going to be taking that issue with our legal entity and not us as individuals. Again, that doesn't mean you have to form an entity, but that's one of the huge reasons, as we talked about at the top, for why so many people think about it from a liability protection. So we've talked about this as well. So we'll just kind of go over it once again. If you're a single member LLC, it's called a disregarded entity. You're going to be taxed pretty much the exact same as if you were a sole proprietor. If there are multiple owners, you're going to be taxed as what's called a partnership. It's still very similar with everything passing through to the owners on a profit and loss scale. And then the individual partners will receive what's called a K1 report, which is going to indicate their share of their profit and losses. Again, technically, you could elect to be taxed as even a C-Corp. That would be incredibly rare that we see people do that. Or you can elect to be taxed as an S-Corp because through the advice of your CPA, he or she has said, hey, listen, I think you're going to save some money here annually on taxes. The tax implications of the S-Corp are going to come again back to the idea of it's a little bit more rigid of a structure. It's still a pass-through entity with profits and losses flowing down, but profits and losses have to be allocated based on your ownership in the entity. And you cannot kind of vary those with a lot of ease. And then if you are an S-Corp, you're going to have to consider things like establishing payroll, because if you're actively managing the business, you cannot say you're only taking your money as profit distributions. You need to be taking what's called a reasonable salary, which I'm not a CPA, but a lot of CPAs will frequently tell you is going to be somewhere in the neighborhood of half of what you would have otherwise made. If you were going to make $100,000, $50,000 of that would be in salary. There are some other advantages that I believe can come, and I'm not an expert here, but this is through talking through being on phone calls with clients and talking through my own financial advisors, is that I think you have more flexibility of what you'd want to do if you have a legal entity from a retirement savings standpoint. And because of the fact that there can be some tax advantages to taking a large portion of the income you would make and putting it towards retirement, this can also be another reason that switching from a sole proprietorship to something like an LLC or an S-Corp situation can make sense for you. I think a lot of this from that point forward, and this is why you're going to want to kind of talk to a financial advisor, is, for us and our business of 5, it's made a lot of sense to have the SEP IRA just because of the administrative costs are less, and we have a pretty simplified retirement structure for how we're giving money to all of our employees based on their wages. However, I believe you can kind of vary those structures and possibly have more advantageous options for your team If you get bigger than that, and that's where you can start looking into things like a 401k. And so this can be another reason, on top of like liability protection, on top of just traditional annual tax savings, you can have some potential long-term planning benefits to forming an entity as well, because you may have some more retirement at your disposal. Whereas I believe if you're a sole proprietorship and you're looking at something more like a traditional Roth, you're going to be limited in your contributions amounts up to around $6,000, maybe $7,000, depending on your age. Whereas if we look at things like the SEP IRA, we can see that, you know, you're allowed to contribute up to $58,000 or 25% of your compensation, with a cap of $290K based on your wages. So you may just be able to stock a lot more money away for retirement. So as we kind of are starting to come here towards the end and open it up for you know, questions from everybody that's attending, I wanted to just kind of touch on, you know, when we're working on this type of structure, there's often a number of questions people ask me that tie into them thinking. And so, you know, a common one is, hey, I gave my wife example, like, how much do I need to justify forming a legal entity? You're going to hear various results here. Some CPAs say, hey, you could start seeing tax savings as soon as if you're making $50,000 by making an S-Corp election. I think that's a bit aggressive. I more commonly hear somewhere in the $75,000 to $100,000 range. Obviously, there's still things like the liability protection, which come into play here. But, you know, because of the fact that California is not a cheap state to operate a business in, I think if the entity itself, or if the business is making less than $30,000 a year, you really have to think long and hard about it. I think if it's generating $50,000 a year, it's worth at least discussing. And then as you start to hit towards six figures, I think it starts to become a no-brainer between, you know, the liability protection, tax savings, all that type of stuff. If you plan to kind of produce more than just consulting and you want to kind of have a hybrid, should you combine it all under one roof? Maybe we often have people that are brilliant consultants, but they're also working on kind of a tech product or something on the side that they may want to someday seek venture funding for. That can work, at least at the beginning. We don't recommend kind of combining multiple businesses under one roof for very long. The issue is that the sins of one can take down the sins of the other. That's frequently why, if you were to peel back the onion on businesses like a hotel, each location is going to have its own legal entity. So if there's a slip and fall at one, the assets and the building at other locations are not kind of taken down. Similar kind of logic applies here if you're running kind of multiple lines of business. As we talked about, if I make the S-Corp election, what's the minimum salary I can pay myself? Well, certainly you're not going to want to pay yourself below minimum wage, you know, around the $15 an hour mark. But also most CPAs are going to tell you that to not risk like a heavy audit here, half of your income needs to kind of come from wages, right? And there can be strategic reasons why that income should be even higher than half. As we talked about in the SEP IRA example, you're allowed to kind of put forth a lot more money then potentially towards retirement savings, because it's based on potentially like the wages you're paying yourself. Is it okay to just 1099 all the help I need to complete projects? That's usually not wise as well. You often want to kind of think about maybe forming with another kind of legal entity if you're going to go that route, to provide some protection as well there from like a labor and compliance issue. And so you also want to look at like how frequently you're using them, and if it's going to make sense for you to want to think about making them your own employee. Do I need a CPA or can I handle my own taxes? I'll just kind of say this. I mean, I have a CPA. I don't make any moves for my law firm without kind of consulting her. I kind of live and breathe this stuff, which is so frequently engaged in taxation, and I still want the advice of a trained professional. I know the Bay Area is expensive, but there's lots of pretty cost-effective options. And I think that, you know, you can end up kind of getting bit really badly from poor tax planning. And so I think the couple, you know, 500 to a couple thousand, depending on the complexity of your structure of the advice you're going to get, filing your taxes is going to go a long way. Why should I not just use LegalZoom as a popular one we get? Look, the way we kind of look at it is it's just not an apples to apples comparison when working with a lawyer. LegalZoom to us is very similar to having like a terrible headache or pain in your body and saying, I'll just take Tylenol or Advil. That very well may alleviate it. But unlike, you know, what we do as lawyers and professionals is we are actually like looking under the hood. We're doing diagnostics, making sure that the structure you're setting up makes sense here. advising you on things like how maybe things like the S-Corp could make sense. And so LegalZoom is just providing a one solution fits all, right off the shelf scenario. And so, we frequently, I would say in the 10 to 20 projects a year range, come for people and have to clean up a mess that was the result of LegalZoom, because LegalZoom, you can absolutely say this is biased, but they try to kind of strike the balance of saying, we're not really lawyers, but here's kind of legal paperwork. And I think that kind of creates issues. Do you need insurance? That's a little bit more of a judgment call depending on, the size of your business and what you're doing. I'm obviously a little bit cynical about insurance because of the fact that they stay very profitable by denying claims. So if you are going to seek insurance, I definitely recommend you get a broker, somebody you feel like is trustworthy, and shooting you straight on what you kind of need and don't need. And my contact information is about to come up. I'm happy to kind of pass along some names. And then the last one I frequently get is sometimes people come to me because, hey, maybe they've left a job and they're thinking of starting kind of an LLC, but they're actually still really flirting with leaving the state or accepting another W-2. Look, as I mentioned, California is not the cheapest state to get an entity formed. And so if in the very near future you think, I'm going to kind of walk away from this consulting business, I do think that impacts things. And you probably don't want to go through the hassle if you're going to kind of reverse course or pivot pretty soon. That might be different if you're in other states because the costs are cheaper. But in California, it means, probably just do a little bit of a heavier analysis. And so with that, I think we'll open it up to some Q&As that Katie's going to lead. And I'll just kind of put my contact information here at the end, where you can find our website. This is my email. This is our office line. After this call, feel free to follow up with me if I can be of further assistance.
Awesome. Thanks, Alex. So much information in 37 minutes. I've learned a lot, which is great. So thank you to all of those too who have already submitted questions. We have a pretty good question roster. And as I mentioned earlier, please submit any and all future questions using Zoom's Q&A functionality at the bottom of your screen, and we'll get to as many as we can. So let's dive right in. So we have one question asking, why is California LLC taxation so much higher than other states? $800 versus $50 in many states.
It's a good question. I think California would tell you that similar to why real estate is so expensive here, that it's a state that stands alone from others. I think I mentioned that the last time I heard that the California was the 6th largest economy in the world, not just kind of, the United States. And so rightly or wrongly, I think that because of kind of the robust nature of the economy and the opportunities here, they look at it as a little bit of a pay to play. But look, as a fellow small business owner and as somebody that makes not a single dollar off of those fees we all pay, I absolutely wish they were lower too. My guess is that would be somewhat the nature of their justification. And also just the size of the state and the amount of businesses that are here. We obviously hear a lot about places like Delaware being a corporate haven, and that's not an untrue statement. But I think the population of California is bigger than all of Canada. And so I think, they would also just say the amount of staffing we have to potentially do all these businesses make us different than, say, I actually don't know how big Kentucky or Montana or some of these states are, but because of just how large we are, that's why we justify the fees.
Cool. Great. And we have a bunch of questions around S-Corps and single member LLCs. So the first one here, can I put myself on a W-2 salary in a single member LLC without an S-Corp election?
You cannot.
Okay.
So that's one of the reasons that people consider the S-Corp so strongly, is from things like possible retirement benefits and also what we talked about, saving some on profit distributions. This is why the S-Corp election makes a lot of sense. If you, and to be clear, just to go one step further, you also can't set yourself up on a W-2 salary if you're a multi-member LLC. You still would have to just be taxed as a partnership, and you can do some things that kind of mimic salaries called like guaranteed payments, but you're going to pay all of the partnership taxation that would be different from kind of a W-2. So really the only way as an LLC is to make the S-Corp tax election.
Okay. And you mentioned profit distributions. We had a question about that. One person asks if profit distributions are non-taxable income for this person personally, or is a lower tax rate than W-2 income?
Lower tax rate, and that's why people like it, right? So let's use a business that makes 150,000 in gross revenue, and then let's assume that business has $30,000 in expenses, fees like the $800 to the state of California, their CPA, their new MacBook. That leaves $120,000 left over, right? And if you paid yourself $60,000, that's another business expense, right? Because it's a salary you're paying an employee of the entity, even though you're the owner and the employee. Now we've got $90,000 in expenses, leaving another $60,000 left over for profit distribution. That profit distribution is going to be taxed at a lower rate. And that's why this can be popular for people who want to possibly save on taxes.
Great. And what about using expense reimbursements for normal items that you would spend money on anyway? So like a phone bill or internet, for example.
You should be able to do that almost no matter what's your entity if you're running a business. If you're a sole proprietorship, you can write that off against earnings, so that it's a business deduction before any of that comes back to you as either profit, salary, whatever it might be. So as long as you're running a legit business, you're going to be able to write off the reasonable expenses you're incurring. And if you have questions about those, you definitely should be running those by your CPA. I run expenses by my CPA almost quarterly to make sure we're classifying them in the right category. But after that, it really kind of does not matter the structure, whether you're a corporation, LLC, or a sole proprietorship, or a professional corporation like I am, or a nonprofit. You're going to be able to kind of write off these expenses.
Great. And we have a question on whether or not you can switch to an S-Corp taxation structure in the future after choosing the default tax structure upon starting an LLC.
You can. It's a really good question. So when you form an entity, because again, you have to have some entity before you even have the option to make an S-Corp election, you're going to have 75 days to make the election in that year. So hypothetically, if you formed it today, you would have 75 days from today to allow it to apply for the 2021 calendar year. If you did not do that in 2021 and you missed that window, technically, without getting too deep in it, there's a second bite of the apple that a lawyer or a CPA can help you with to file a late election, but there is no guarantee that the IRS will accept it. What you have moving forward is then again, every calendar year, you have until March 15th to file the election. So if you didn't do it in 2021, you could file it by March 15th of 2022. And assuming your filing was done correctly, meaning like you signed in the right boxes and gave them the right information, they're going to accept it if it's filed timely type of thing. And then once it's accepted, you never have to file it again. You're then just an S-Corp moving forward unless you revoke that S-Corp election by either your actions. You can revoke it by doing something that's improper, like as we talked about, going over 100 shareholders. As soon as you gave equity to 101 shareholders, it would revoke the S-Corp election because you're violating the rules. Or you can actually voluntarily revoke it by contacting the IRS saying, I don't want to be an S-Corp anymore. But if you make the S-Corp election and then you revoke it, your entity can't be for another 5 years. You have to stay back at whatever you went back to.
Interesting. Okay, that's good to know. And I think we've talked a little bit about timing. So one person asks, and doesn't specify what type, but he says, if a corporation is set up before the end of this year, can it retroactively apply to the revenue and expenses for the whole year? And then his follow-up is, what about estimated taxes that have already been paid?
Yeah, well, follow-up question was about, okay, estimated taxes already been paid. So I think I can answer both of them with kind of the same answer, because what happens is once you form an entity, think of the entity as like almost like a new individual, right? Like we are birthing that entity or individual on the date it is formed. So we can't retroactively go backdate anything because the entity didn't exist, right? So there's not an opportunity to say, hey, Acme Consulting wants to pay S-Corp tax elections in March of 2021 if it wasn't formed until September 29 of 2021. So similarly, previous like estimated taxes and things that were made are going to have to be based on the structure you were at that time, and you can only really kind of go moving forward.
Great. And we have a question. Someone says they've been seeing ads from a company called Collective that suggests creating an S-Corp if the revenue is at 80K or higher, and then asks, is 80K a special number where tax rates go up, or what's the reason for that being thrown out there?
Yeah, I mean, I think I threw out a similar number, and I think the rationale there, and without having seen this article or this post that this organization is putting out there, is my guess is that, or I'll at least explain my rationale, which I guess is probably my assumption would be pretty similar, is that you kind of need to start getting into that range because again, you got to think about the idea of extra costs of like establishing payroll. You got to think about setting yourself up on your own salary before you can even start taking those profits. So they've probably done some kind of like analysis in which they've said, if you paid yourself 35K in salary, took 35K in profit distributions, had 10,000 expenses, you would start to like break even or start to see a win in taxes. And then from that point forward, continue to see a win. That's my guess on where they've come to that number. I can't tell you exactly how they got to that formula, but that number starts to kind of make sense to me when you think about like an $80,000 business is probably still at least going to have somewhere in the $10,000 range of expenses. And so when you start to think about the tax savings you would get, they're probably limited at those figures and really only start to kind of get higher than that if your profit distributions start hitting 50 or 75 or $100,000.
Cool, great. We have a question. If we have multiple LLCs that are separate entities, are there advantages to owning them under a parent company?
Usually not. Well, there can be, I should say. So I'll give the popular example why you would have kind of a parent company. Let's take the hotel example again. Katie and I, at the billionaires we are, we're going to start a hotel conglomerate. And so her and I are going to be 50-50 partners in hotels. I almost said hotels tonight. That's already a company, whatever. Bay Area Hotels Incorporated. And we're going to be the owners and we're going to have this kind of entity, right? From there, we're probably going to want to have each of our properties in its own LLC and then solely owned by us, right? And so we're going to separate out some of the exposure that could happen to each one of those entities on those different locations. And so that's kind of the example where you see a holding company be valuable, is if the ownership at the top is different from each one of the smaller LLCs. But if I own one LLC and another LLC, another one, there's not a lot of added value to just making me another owner of all the same at the top with a holding company. Because again, if your CPA or tax person says that he or she can find some tax savings, I'll defer to her, but I would say usually not. The one thing that can be valuable with these multiple LLCs is to put, if you're from looking at it from an estate planning purpose, which we didn't really touch on, is if you have like a trust, maybe putting your ownership in the name of all of those trusts. So on the unfortunate likelihood that you were to prematurely pass away, you would allow for an easier succession of ownership. But otherwise, just creating kind of a holding company to create one doesn't make a lot of sense unless there's going to be like maybe investors at the top or various owners.
Great, good answer there. We have a question on whether or not you need an LLC to set up a SEP IRA.
Oh, it's a good question. I don't know that answer with 100% certainty. I believe the answer is probably no, but I don't know that. The only thing that would make me think that it could, that the answer could be yes, is because of the fact that I believe to have a SEP IRA, it needs to be based off wages. So technically, I think a sole proprietor can put themselves on a salary, but they can't do an S-Corp election. So it's possible that you could even without an LLC, but you'd want to look into that further.
Cool. Okay. And another related question to SEP IRA. So one person asks if you have a recommendation for a SEP IRA versus a 401k when it's a single member LLC.
Yeah, I think the reason that a lot of people go with the SEP IRA is it's very straightforward to administer. As someone that kind of works with my team at Morgan Stanley is who helps administer our plan, it's really kind of straightforward. We just have a set percentage of everyone's salary that we contribute. So pick a number, call it 10%. You're going to choose to contribute 10% of your salary. The administrator just kind of pulls that from your wages, puts it into the retirement account, manages it. And it's really pretty straightforward. Again, I have not personally worked with a lot of 401ks, and so I'm not nearly as well versed in those. You could hear that they're just as easy. The recommendation from our team was that this was going to make the most sense and was going to be the most cost effective. So my gut is that for you, the single member LLC, that's also going to make the most sense. But again, I will 1,000,000% defer to whoever you're using to kind of financially plan and help administer it.
Awesome. That's great, Alex. Cool. Well, we've gotten through all the questions we have so far. So we'll give it another maybe 20 seconds in case anybody's been sitting on a question and debating whether or not to ask it. Now's your chance, y'all. But yeah, no, this has been fantastic. Anybody else? Last call for questions.
Yeah, so
right.
well, Katie, just real quick, like I said,
Yeah.
feel free to reach out to me. If I can make introductions to other professionals, like people that have questions on IRAs or retirement, people that have questions in insurance, we have a big swath of a network of people that we've grown to, you know, really like and trust over the years. And so I'm happy to kind of be that resource to help put you in touch with some people to help support your consulting business. So, you know, don't hesitate to kind of say hi and see if I can do something to support.
Awesome. Thank you so much, Alex. On behalf of all of the consultants who joined us today and just Right Side Up in general, we're so grateful for you to join us and share your knowledge and expertise on what is often a very complex, topic for first-time consultants, which many folks are in our network. So thank you again. We really appreciate it.
Absolutely.
Awesome. All right. Thanks, everyone. And as I mentioned, we'll be sharing the recording later this week, so keep an eye out on your email. All right. Take care. Have a great Tuesday.
Thanks.
Bye.